been a lot of talk about so-called race-based laws in South Africa recently, with many on the platform formerly known as Twitter claiming that there are over 140 race-based laws in the country, more now than even during apartheid. These claims have gained traction, even internationally, with figures such as Elon Musk speaking of South Africa having openly racist ownership laws. Much of this recent conversation surrounding the race-based laws in South Africa is a result of backlash to the recently passed Expropriation Act. This act and the idea of more than 140 race-based laws being in existence in South Africa are being used to curate a narrative that white South Africans are being discriminated against and oppressed in modern democratic South Africa. And unfortunately, this narrative is taking root, as can be seen by the US President Trump's recent executive order stating that countless government policies designed to dismantle equal opportunity in employment, education, and business have been implemented in South Africa, and his offer of refugee resettlement to white Afrikaners specifically. The Expropriation Act is a piece of legislation that has been subject to a lot of misinformation and misrepresentation, but there has also been quite a bit of attention paid to correcting this misinformation. I myself have made several videos on TikTok discussing the act and trying to explain it. But what there has been slightly less scrutiny over are the various other pieces of legislation that are being referred to as race laws or race-based laws that are discriminatory or claimed to be discriminatory towards white South Africans. So when I saw that a user on the platform formerly known as Twitter, cthulhucachoo, was compiling a Substack post on these laws, I was very excited. I contributed a little bit to the research that went into that Substack post, and I've decided to further it here to make this video that hopes to answer a few fundamental questions. Firstly, where does this claim of 140 plus race laws come from? Is this claim true? And if so, to what extent is it true? And thirdly, do these laws actually discriminate against white people specifically, as is often claimed? So if you're interested in finding out the answers to those questions, stick around for the rest of this video as we explore the truth behind the 140 plus race laws in South Africa. Probably the easiest of these questions to address is the one of where these claims of race laws actually come from. There are multiple organizations and individuals that have made claims about the number of race laws in South Africa. Some claim that there are simply hundreds of laws. Some specific numbers, like 116, have been floated by organizations like the Free Market Foundation and AfriForum. Willem Petzer has claimed in a memorandum to President Trump that 118 racial laws are in place against white people, specifically in South Africa. The most prominent claim, however, seems to be of this number of 140 plus, and specifically of 142 race-based laws. This claim has been repeated by organizations like Solidarity and Disregard 24, as well as both prominent and non-prominent individuals. This includes Willem Petzer himself, who, when posting about the memorandum in which he specifically cites only 118 laws, claimed that his memorandum detailed 140 plus race-based laws. This specific number of 142 actually comes from the Institute of Race Relations and their Index of Race Law. This is the number and the list that has been used by the Free Market Foundation to make the claim that there are more race-based laws in South Africa now than under apartheid. And as this is the largest list and also the number that seems to be floated around the most and referenced most commonly, it is the one that I will be focusing on for this specific video. The Index of Race Law itself is a website. It can be found at racelaw.co.za. And according to that website, the Index of Race Law is a record of the many South African laws, currently only acts of parliament, that make or made race, skin color, or ethnicity of legal subjects relevant at law, usually by creating racial disabilities and burdens. The index covers the period from the creation of the Union of South Africa in May of 1910 to the present day. It mentions on the website as well that this index is specifically an initiative of the South African Institute of Race Relations, or IRR. According to this website and this index, 317 racial acts of parliament have been adopted since 1910. 117 of those racial acts of parliament have been adopted after 1994. And there are currently 142 racial acts of parliament that are operative today. This index was last updated on the 9th of January 2025 as of the time of recording. The actual index itself is a relatively straightforward list. It can be found on the website and also downloaded as an Excel or CSV document. And it is a straightforward list of all the acts of law that the IRR considers to be race laws. This list includes the act number, the year, a short title of the act, whether the act is pre-democratic or post-democratic, its operative status, and its race law status, which is classified as either racial, racialized, or deracialized. As mentioned, the index tracks both operative and non-operative laws, so in total, they keep a counter of 317 total laws, of which they claim 142 are current operative laws. The index does not contain the sections of these laws that they consider to be race-based or that they consider to make race relevant under the laws, and they also do not provide any extracts from these laws on the index itself. On their FAQ page, they do say that when it comes to the question of will race law be making the full texts of these laws available, that they utilize a paid subscription service to obtain access to full text digital copies of race laws, and therefore they cannot provide the full text of these laws on the index itself because these are paid services that they are using. But they do claim that in time they will provide extracts from the relevant laws that clarify why those laws were deemed to be of a racial character. However, even though the IRR and their race law index seems to have had trouble providing these full extracts of the laws so that people can very easily see what these laws are saying when they are referred to as being race laws, myself, along with the user on the platform formerly known as Twitter, cthulhucachoo, have gone through this extensive list of the 142 laws and actually found all of the sections that we thought might be relevant and might be the reasons that they were included on this index of race laws so that we can actually see what are these laws saying, what are these acts of parliament saying, what are they saying about race, and is this list accurate? Now, this video would probably go on for hours if I went through every single one of the 142 laws listed by the index in detail. So if you want that full breakdown, I would highly recommend checking out the Substack post that will be linked in the description of this video, as that formed the base of a lot of my research for this video anyway. But what I have done is I've gone through all of the laws listed myself in the index and grouped them into broad categories so that I can provide a few examples and discuss as an overview what these types of laws are saying when it comes to race and what the IRR has determined qualifies a law as a race-based or race law. Just as a quick disclaimer, as you can imagine, this was a very tedious task, very tedious work, and these groupings are not necessarily a precise science. It is very possible that I have miscounted, especially for some of the larger groups. There are some laws that you may believe belong better in a different section. I have done the best that I possibly can here in terms of going through all of these 142 laws and trying to make sense of them in a way that allows us to actually interpret and evaluate them in a constructive way. But if you notice any issues with my reasoning groupings, the laws that I am using as examples in this video, then please, I welcome any corrections that you might be able to provide. List them in the comments, refer me to any relevant sections that I might have missed out on or that you think should have been included here, and I will happily make updates and corrections as and when is needed. But with that disclaimer out of the way, let's just get straight in and dive into looking at what these laws actually say. The largest group of laws listed in the index is a group that refers to demographic representation in some way. By my count, there are 48 of these laws that refer to representation in some manner. And for the majority, at least as far as I can tell, the sections calling for representation are the only sections of the law that are related to race in any way. Again, we don't want to be here for hours, so I'm not going to go through all 48, but I am going to provide a few brief examples of how this reference to representation might be worded, as many of these laws actually follow very similar wording when it comes to these sections. The first example that I'm going to provide is from Act 54, the Legal Deposit Act of 1997. This is an operative law that states in Section 8.1, in establishing the Legal Deposit Committee, regulations prescribing the manner of designation shall apply the principles of transparency and representativity. Another example that I can provide is from the Higher Education Act 101 of 1997 as well. In this act, Section 8.2c states that the selection of the chairperson, ordinary members, and co-opted members must be undertaken in such a manner as to ensure, insofar as is practically possible, that due attention is given to representativity on such relevant grounds as race and disability. Another example is the South African Library for the Blind Act 91 of 1998. This act in section 6(1)(a) states that members appointed to the board be appointed according to principles of transparency and representativity, and that expertise in financial matters and matters affecting blind and print handicapped readers must be represented on the board. Another example, the Land Agricultural Development Bank Act 15 of 2002 in section 8(6)(a) states board members viewed collectively must represent a broad cross-section of the population of the Republic. And one final example is the Public Administration Management Act of 2014. This is Act 11, and Section 4(i) states each institution must ensure broad representation of the South African people with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalances of the past to achieve broad representation. There are a couple of other examples where the wording might vary slightly, but these few examples that I've provided should give you a pretty good idea of how the references to representation might be worded. And with that, there are a couple of key things that I want to point out. Firstly, many of these sections don't actually explicitly mention race. Instead, you may have noticed that there were general references to transparency and representativity. And secondly, while some sections in some of these acts used strong wording like must ensure, there are many that are a lot more suggestive in their wording, stating as far as practically possible, or stating that representation must simply be considered. And I think those 2 points are really important to keep in mind when evaluating these laws as race laws, especially when taken with the fact that, like mentioned previously, for many of these laws, these sections in the act that speak about representativity are the only sections that in any way make race relevant. The next grouping of laws that I have identified are laws that broadly relate or refer to the idea of historic disadvantage. By my count, there are 39 of these laws included on the Race Index. It is important to note that many of these laws do have additional sections that the Race Index might consider relevant and might consider as making race or ethnicity relevant. For example, many of these laws also have sections that call for representation, with many following very similar wording to the laws discussed in the previous section. So with that in mind, I'm going to give you some example of how these laws might refer to historic disadvantage. First, we have the South African Schools Act. This is Act 84 of 1996, and in Chapter 434(1), it states, the state must fund public schools from public revenue on an equitable basis in order to ensure the proper exercise of the rights of learners to education and the redress of past inequalities in education provision. Another example might be Section 3 of the National Film and Video Foundation Act 73 of 1997, which states to provide and encourage the provision of opportunities for persons, especially from disadvantaged communities, to get involved with the film and video industry, as well as, in respect of the film and video industry, to address historical imbalances in the infrastructure and distribution of skills and resources. And as a final example, I can use the Electronic Communications Act 36 of 2005, which has several sections that could be considered as being related to race in some way, one of which specifically says that it is intended to promote the empowerment of historically disadvantaged persons, including Black people, with particular attention to the needs of women, opportunities for youth, and challenges for people with disabilities. Again, these are just a few examples. There are many, many ways that this reference to historic disadvantage can be worded, but I think it gives you a good enough idea of what these sort of laws and sections might look like. Now, in terms of why these are all included on the Race Index, I'm assuming that these laws have all been included in the index because of the reference to historic disadvantage, as in a country with a history of apartheid, it makes sense that there is a racial component to who is considered historically disadvantaged. However, I do think it is very important to note that the definition of historically disadvantaged individuals in South Africa includes more than just those who were affected by the racial discrimination of apartheid. According to definitions that can be found in a number of different legal documents, a historically disadvantaged individual or person means a South African citizen who, due to apartheid policy that had been in place, had no franchise in national elections prior to the introduction of the Constitution of the Republic of South Africa in 1983, or the Constitution of the Republic in 1993, or who is a female, and or who has a disability. Therefore, although obviously there is clearly a racial component to this definition, it is not solely a racial classification. which I believe is important to keep in mind when considering that these sections of these laws are being used to class them as race laws. The next section of laws that I want to discuss is a group of laws that include broad-based Black economic empowerment, as well as laws that refer to it. Again, some of these laws may have additional sections that could be considered racial, for example, sections referring to historic disadvantage or sections referring to representativity. However, for the purpose of this video, I have grouped them together and we will focus on the fact that they refer to broad-based Black economic empowerment in our evaluation here. So, for example, here we have the Cross-Border Road Transportation Act 4 of 1998, which states when the applicant is a South African carrier, the board must take into account the empowerment of persons historically disadvantaged by unfair discrimination and any relevant code of good practice or transformation charter published in terms of the Broad-Based Black Economic Empowerment Act. Or the Insurance Act 18 of 2017, which refers to transformation of the insurance sector, meaning transformation as envisioned by the Financial Sector Code for Broad-Based Black Economic Empowerment, issued in terms of Section 9(1) of the Broad-Based Black Economic Empowerment Act 2003. So the reason that I've grouped all these laws together is because when people say that they have an issue with race laws or race-based laws in South Africa and cite this list of 142 laws, I don't really think they have an issue specifically with the Insurance Act of 2017. I believe that they have an issue with broad-based Black economic empowerment and then by extension have an issue with any law that refers to it. I don't think there's a particular issue with all the various other sections and provisions of the Insurance Act, but rather it is the fact that the Insurance Act is referring to broad-based Black economic empowerment that is the cause of concern, for lack of a better word. So, an in-depth discussion here on the merits and flaws of broad-based Black economic empowerment as a piece of legislation is way beyond the scope of this video, and again, I don't want to keep you here for too long, but the point that I would like to raise here is that a number of laws that are not necessarily inherently racial in themselves are included on this list and are classified as racial because they refer to complying with, or just generally refer to, legislation that is considered racial by nature. The next section is very similar to the previous section, and it is a grouping of laws that refer to the Employment Equity Act, including the Employment Equity Act itself, and this in total is a group of 6 laws that I have counted or identified. As just one example here, the National Health Act 61 of 2003 states, before the Director General issues or renews a certificate of need, he or she must take into account the need to promote an equitable distribution and rationalization of health services and healthcare resources, and the need to correct inequalities based on racial, gender, economic, and geographical factors, as well as the need to protect or advance persons or categories of persons designated in terms of the Employment Equity Act. And again, as with the previous grouping of laws, there may be other sections in some of these laws that also do, according to the IRR, make race relevant in some way, but I've grouped them primarily on the fact that they refer to the Employment Equity Act, as I feel like that is kind of the main reason why laws like this would be included in the race index. Of course, it is difficult and impossible to know for sure because the index itself does not provide the sections that they take issue with or that they use to consider a law a race law. Again, there may be some other sections within the pieces of legislation that I have grouped together under this grouping of referring to the Employment Equity Act that may be considered by the IRR to make race relevant, but I think the main point is the employment equity itself. And again, like with broad-based Black economic empowerment and the laws referring to it, I think the actual issue is with the Employment Equity Act itself, not necessarily with the pieces of legislation that just refer to it. And again, this video's purpose is not necessarily to debate the merits of the Employment Equity Act, but as with the laws about broad-based Black economic empowerment, there are a number of laws here that are not necessarily inherently racial themselves, but are being classified as racial because they refer to complying with the Employment Equity Act, which I believe, obviously, the IRR is considering an overtly racial piece of legislation. Okay, moving on to the next section, and this group is actually very interesting and a very telling one because it is a group that I would argue has no reason to be listed as operative race laws by the index. This is a group of 9 laws, all pre-democratic laws, that by the admission of the index itself no longer contain racial provisions. So on the index on the website, they classify laws as being either repealed or operative, as well as either racialized, or deracialized. There are a group of 9 laws that are considered to be operative and also considered to be deracialized. According to the index itself, the website says laws marked as deracialized are laws that are operative today or by the time that they were repealed no longer contained racial disabilities like they once did. It will take some time for us to discover which especially historical laws ended their periods of operation racially or deracialized. Now, the fact that these laws are included or listed on the index would not necessarily be an issue if we consider the index to be a purely educational exercise aimed at categorizing various laws in South Africa. Or at least it wouldn't be an issue if they weren't included, these 9 laws weren't included as part of the 142 laws that are deemed as operative race laws in South Africa. Because on the front page of their website, in a big blue box, it states 142 racial acts of parliament are operative today. But by the index's own admission and categorization, 9 of those 142 laws are no longer racial. They are deracialized laws. This is a blatant deception from the IRR and their index. A law cannot both be deracialized and considered an operative race law at the same time. This is a blatant contradiction and calls into question the integrity, legitimacy, and intention behind this index as a whole, in my opinion. Now, the next group of laws that I'm going to talk about follows a very similar vein to the previous grouping, and it is a number of laws that are from the pre-democratic era that do not seem to be relevant in modern democratic South Africa or are considered by legal professionals to be functionally repealed by obsolescence. By my count, there are 14 of these laws that are really no longer relevant today. And I'm going to give you some examples just to illustrate what I mean. So, for example, the Bethelsdorp Settlement Act of 1921, Act 34, is listed as an operative racial law by the index because Part 1.4 states, shall be owned and occupied by coloured people and natives only. That is at least what I can gather in terms of why it was included on this index. But if you go and read the entirety of the Bethelsdorp Settlement Act, you might realize that no one is applying this law in modern democratic South Africa. This is a law, as far as I can tell, again, this was a law from 1921, so I might be misinterpreting slightly, but it seems like it was talking about government expropriating land in Bethelsdorp. Essentially, it's about the land in the Bethelsdorp settlement, which is a town in the Eastern Cape, and how that land was going to be essentially owned and managed and distributed between the government and like a church ministry. No one is applying this law practically in South Africa today. I just don't think this is in any way relevant to the conversations that we are having about race law in South Africa in the modern era. Another example would be the Coloured Persons Education Act 47 of 1963. This is again listed as an operative racial law, and if you look at the actual law itself, the 3 laws that this law was put in place to amend have all been repealed. It was the Special Education Act of 1948 and the Vocational Education Act of 1955 that this law was meant to amend. Both of those were repealed in 1967 already. And then this law also amended the Republic of South Africa Constitution Act of 1961. And obviously that constitution was repealed in 1994. And obviously, if we think a little bit logically about this law is called the Coloured Persons Education Act. We no longer have a separate system of education in South Africa. So how exactly would this law be relevant in modern democratic South Africa? The answer is it's not. A final example from this section is the Alienation of Land Act 68 of 1981. This excludes land which forms part of any Schedule 30 black area as defined in Section 49 of the Development, Trust and Land Act of 1936. Again, not relevant in modern South Africa because we do not have areas defined as black areas anymore. That's just simply not relevant in South Africa today. I mentioned in the intro to this section that these laws may be considered functionally repealed by obsolescence. As discussed here in the South African Law Commission Discussion 140, this essentially means that the law no longer has effect. Now, I am definitely not a lawyer and cannot say for absolute certain, but from my reading, interpretation, and understanding of these 14 laws, I would say that they are probably going to fall under that category of repealed functionally by obsolescence. To be fair, the Race Law Index does acknowledge this idea and phenomenon, they just choose to ignore it. Their website states laws marked as repealed are laws that were formally and explicitly repealed by later laws, although it is understood in law that a new statute can, by necessarily implication, repeal an older statute if there is a total incongruence between the two. The practice has been for the process to be explicit, not implicit. So this is the logic that they are using in order to keep these laws on their index. Now, including these on the index would maybe not necessarily be an issue if the index was listing these and then calling for these laws to be formally repealed, because these are laws that are technically still operative. The index is right in that they are technically still operative laws. And although they are functionally obsolete, they are not technically repealed. So if the index was listing these laws and saying, hey, maybe these should be actually formally repealed, that would be one thing. But based on a lot of what we've already seen here, I think we can agree that that's not necessarily the intention of this list itself. And therefore, I think the inclusion of these on the list raises some concerns and skepticism, at least for me it does. Moving on to our second last section here. This is laws that refer to the collection of data on race. This is a pretty small group. It is just a group of 2 laws that refer to the collection of data on race in some way. So I'm going to read out both of the examples that we have here, just so you can get an idea of what exactly these laws are saying, since it is such a small section. One of these is actually a pre-democratic law. It is the Deed Registries Act of 1937, Act 47, but this was racialized later. And it says it includes provisions for the minister to make regulations in respect to the collection of personal information relating to race, gender, citizenship, and nationality for statistical and land audit purposes. The second one is the Protection of Personal Information Act. You might know it as the POPI Act. This is Act 4 of 2013, and it states that a responsible party may, subject to Section 27, not process personal information concerning race or ethnic origin, and the prohibition on processing personal information concerning a data subject's race or ethnic origin, as referred to in Section 26, does not apply if the processing is carried out to identify data subjects and only when this is essential for that purpose and comply with laws and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination. That was a long one. So those are the 2 laws that refer to data collection around race. I think you could probably also make an argument that the POPI Act could possibly fall under the historical disadvantage section. It does kind of mention persons disadvantaged by unfair discrimination, although interestingly enough, it doesn't specifically mention historic disadvantage. It just says disadvantaged by discrimination. So in my opinion, that would include present discrimination. Again, I'm not a lawyer. I don't know if I've said that actually already in this video, but I'm not a lawyer. So this is just like my evaluation and interpretation. If you want to double check this, if you are a lawyer, please feel free to do so. But yeah. Anyway, besides the point, moving on, that's our short section on 2 laws that refer to collection of data on race, and means we can move on to our final section, which is a section that I have just broadly classed as other, because these were ones that maybe didn't quite fit into any of the previous sections that we've discussed. Now, this section is very interesting. It is a collection of 11 laws, and I'm going to take the time to go through almost all of them because there are a couple of them that really illustrate what, in my opinion, are the flaws of the curation of this list, this race index. First up, we have the Marriage Act of 1961. And in the Marriage Act of 1961, there are 2 points where it refers to the solemnization of marriages within people of a specified race or persons belonging to a specified race. And that's why I believe that this was included in the Race Law Index. So, for example, it says that the minister and any officer in the public service authorized thereto by him may designate any officer or employee in the public service or the diplomatic or consular services of the Union to be, by virtue of his office, and so long as he holds such office, a marriage officer, either generally or for any specified race or class of persons or country or area. I didn't include this in the one that, the section of like functionally obsolete or like mostly repealed acts, because as far as I can tell, the Marriage Act is still very much in effect. But I just don't really believe that these sections are super relevant in modern South Africa. Again, lawyers, come correct me if I'm wrong, but I don't think we are really like classing ministers and like marriage officers as only being able to perform marriages for specified races. Again, I think you can make the argument that maybe this section should be removed and this wording updated and changed, but I don't know how I feel about this being included in an index of race laws when it really doesn't seem like that is super relevant today. The next law that I've included in this other section is the Law of Evidence Amendment Act. This is an act from 1988, and essentially, from what I can tell, this makes accommodation for Indigenous law, and I believe that is the reason that it was included in the race index. So that is why I put it in the other section, because it didn't quite fit into the others, although I do believe that probably the IRR thinks that making accommodation for Indigenous law makes something a race law or race-based law. The next one is the National Small Enterprise Act of 1996. This is classed as an operative racial law. And when I was reading through this entire National Small Enterprise Act, I could not actually find any reference to race. This is listed as a racial law, so something that was originally like included within the act. It's not listed as being racialized later. So I'm assuming that the racialized components are not found in any of the amendments based on the information that has been provided to us by the race index and the IRR itself. But literally the only thing that I could find that I thought might be the reason that it was included in this list was that when you do a keyword search for the word or the term white, you get to a section. This is in the definitions, chapter 1(1)(x), which says National Small Business Support Strategy means the national policy in respect to small businesses support as published by the Minister in the Gazette, and includes the policy as stated in the white paper on the National Strategy for the Development and Promotion of Small Businesses in South Africa. So the only thing that I can really think of here is that a keyword search was done for black, white, race, those sorts of terms. They saw that there was a hit for the term white and then put it in the list. That's kind of what I'm assuming happened here. Again, I could be wrong. Maybe I'm just not seeing something, but it's only an 11-page act. I read through pretty much the entire thing, and I did not find anything else or any other reason that would warrant it being included in this index. Okay, the next one then to move on to talk about is the Promotion of Equality and Prevention of Unfair Discrimination Act of 2000. This is Act 4. It is obviously an operative act, and I believe that there are many sections that could have been taken issue with here. Essentially, the whole act is about the elimination of discrimination, and there's obviously then a lot of mention of race, like elimination, prevent unfair discrimination on the basis of race. There's particularly a section that refers to the existence of systematic discrimination and inequalities, particularly in respect of race, gender, and disability in all spheres of life as a result of past and present unfair discrimination brought about by colonialism, the apartheid system, and patriarchy, and the need to take measures at all levels to eliminate such discrimination. So I'm assuming that is why this law was included in the index. Again, I'll let you come up to your own interpretations of how you feel about that law being classed as a race law in South Africa. But I also would recommend that if you think that there's something that I'm missing, go ahead and read the whole act, the whole piece of legislation, and let me know why you think it was included. The next one is the Local Government Municipal Systems Act, which again is classed as an operative racial act. This is Act 32 from 2000. And this says that when establishing mechanisms, processes, and procedures, the municipality must take into account the special needs of people who cannot read, write, people with disabilities, women, and other disadvantaged groups. So again, this is one that probably could have fit into the historical disadvantaged section. The wording was like a little bit different to some of the others. And I also wanted to particularly make note of the fact that this is specifically a section that is calling for taking into account the needs of people who cannot read or write in terms of municipal systems. And that section, because it also, I'm assuming, contains reference to other disadvantaged groups, has been classed as a race law. Next one is the South African Boxing Act of 2001. This is Act 11, and in two different sections here, there is reference to transformation, which I believe is why this one was flagged and included in the race index. Specifically, section 9 says that must consist of members appointed based on their expertise and knowledge of women's and amateur boxing media and marketing related matters and development and transformation. So that's one of the sections why I believe the Boxing Act was included in this list. The next one is one that I really don't think should be included in this list at all. It is the National Environmental Management Protected Areas Act of 2003. This is Act 57. And again, I think this was included because of a simple keyword search. Someone did a keyword search and found that this act specifically refers to diversity, and it was therefore included. However, when you actually read the law itself and when you read the sections, it is very clear that it is not talking about diversity of race, diversity of people actually at all. Instead, this is referring to like the biological diversity of plants. Particularly, for example, Section 17A of this Act says to protect the ecologically viable areas representative of South Africa's biological diversity and its natural landscapes and seascapes in a system of protected areas. There is also one mention of race in this act, and it's when they define the term species as means a kind of animal, plant, or other organism, including any subspecies, cultivar, variety, geographic race, strain, hybrid, or geographically separate population. So again, if you can find somewhere in this act that actually refers to race and makes race of people, persons in South Africa relevant, I would welcome the correction. But as far as I can tell, there is absolutely nothing. I read through the entire act and could find nothing really that actually refers to the race of people or makes it legally relevant in any way. And therefore, I don't think this should be included in the race index. The next one to look at is the Cooperatives Act of 2005. This has a couple of sections, particularly like the preamble and section 2B, and essentially it says promote equity and greater participation by Black persons, especially those in rural areas, women, persons of disability, and youth in the formation of and management of cooperatives. So again, this is very similar to the types of laws that we discussed in the historic disadvantage section. I didn't put it there because it doesn't specifically use the words historically disadvantaged. This is one of the rare times where the term Black persons or Black people is actually used in place of terming like historic disadvantage. But as we can see here, it's essentially meaning the same thing because it's also considering women and people with disabilities as well as youth, and also specifically refers to people in rural areas. So that is something to consider when looking at this one and evaluating it as a race law. Next up is the National Environmental Management Waste Act of 2008. This is a very similar situation to the Protected Areas Act, where again, I read through the whole act and I could not find anything relating to making race legally relevant. The only section that could be somewhat relevant is a section that says the diversity, complexity, and competitive nature of the industry concerned would make it impracticable for a category of persons other than an organ of state or provincial department responsible for environmental affairs to prepare the plan. So again, this really seems like a situation where someone did a Control F for the word diversity, saw that diversity was mentioned, and said, great, let's include it on the index. Once again, if you can find the section of this act that is relevant or makes race relevant, please let me know. I'll be happy to make a correction. But as far as I can tell, this should not be included on any index of race laws. Next one, our second last one to discuss, is the Superior Court Act. This is from 2013, and it states, with the advent of the democratic constitutional dispensation in 1994, the Republic inherited a fragmented court structure and infrastructure which were largely derived from our colonial history and were subsequently further structured to serve the segregation objectives of the apartheid dispensation. And this is essentially just in that entire first section of some pieces of legislation where it says considering, whereas, noting that, and it's basically just saying we need to recognize that we inherited a fragmented court structure as a result of apartheid, and that there was a lot of consequences of the colonial history and apartheid history on the court system, and that needs to be considered in this 2013 Superior Courts Act. And then finally, the last one is the Spatial Planning and Land Use Management Act of 2013. This is Act 16. And essentially, this entire act is just to provide a framework for spatial planning, and obviously a large part of that does include reference to historically disadvantaged persons, the former idea that spatial planning during apartheid was done on the basis of race obviously informs a lot of this spatial planning act, and there's attempts to redress and correct that, which is why I believe this was included. I haven't pointed out specific sections here because essentially it's just the entire act. A lot of it does refer to race in some way, in the sense of correcting the historic imbalances of the past. So again, probably one that fits in a very similar line to the historic imbalance and historically disadvantaged peoples section. However, it is slightly broader, more encompassing, and does refer to race in a number of different ways. So I've included it in the other section. But that brings us to the end of going through all 142 of these laws. Well, not exactly all 142, but in some way through these groupings, we've kind of touched on all of the different types of laws that are included in this race index. So now that we have actually gone through all of these laws, we can look at answering those last two of the three questions that I posed at the beginning of this video. So firstly, are there 142 race laws in South Africa? I would say definitely not. Obviously, the 9 deracialized laws included on the list mean that there are categorically less than 142. And there were 3 laws that I identified that do not refer to race in any way whatsoever and should not be included in that list, that reduce the number even further. I would also argue that the non-democratic and non-relevant, functionally obsolete laws should be removed from the list as well. So if we're being generous and we remove those functionally obsolete, deracialized, and the 4 that do not appear to in any way be about race or redress or transformation or diversity of people, actually, we get a total number of 116 laws. Funnily enough, this matches up with the number that is floated by some people as being race legislation or race laws in South Africa. AfriForum has used this number of 116 a couple of times in the past, so maybe that is where they get that number specifically from. But I think that you could also argue for even fewer laws than that to be included as actually being considered race laws. Going through these laws, I found 43 that explicitly refer to race, either by using the word race, racial, or using terms like black, white, colored, etc. Now, you might argue that that might be too strict a definition, that it should be slightly broader than just laws that explicitly refer to race or racial categorizations. But I think it's also worth questioning whether a law that just references transparency and representation in only one section, when the rest of the law has nothing to do with race, should be considered a race law and is worthy of being placed on an index of race laws. So with that in mind, I can't give you an exact number of race laws in South Africa. But what I can tell you is that it is definitely not 142. It may be as high as 116 depending on what you define and what you decide to classify as a race law, but categorically there are not 142 race laws in South Africa. And I would challenge anyone claiming such to actually prove it by listing out the laws and the sections, relevant sections, that mean and make those laws race laws. The next question to interrogate is, do the 142 race laws as listed by the Race Law Index discriminate against white people? And before we answer this question, I want to make it really clear that it is not the IRR or the Race Law website itself making the claim that these laws are discriminatory towards white people. In fact, I think it very deliberately, the website and the index itself does not make any claim about whether these laws are discriminatory towards white people or not. But many people online are seeing this list, seeing the number of 142, and then are using it to make the claim that these laws are discriminatory towards white people. So I think it is a question and a claim worth evaluating. Additionally, many people who might not have even seen the list at all are seeing other people cite this number of 142 and then are using and copying that number of 142 or 140 plus and making again the similar claims that these laws are discriminatory against white people. So, are there 142 laws or 140 plus laws that are discriminatory towards white people in South Africa? Well, As we've already identified, many of the laws are not even race laws, so we can very easily say that the answer to that question is no, but for the sake of the academic exercise, let's break it down even further and ask if the laws that are race laws, even if we're being generous, and we include that entire number of 116 that we reduced it down to, are those laws discriminatory against white people? I would say no. None of these laws unfairly discriminate against white people. It is very clear that they have been put in place to address the historic injustice committed during apartheid and are an attempt to correct the massive material inequalities that still exist in this country today as a result of apartheid. But even if you disagree with that logic, and even if you're coming in with a different frame of mind, many of these laws actually actively include white people in their provisions. As mentioned when discussing the section on laws that address historic disadvantage, the definition of who is considered historically disadvantaged includes women and disabled people. And last time I checked, white women and white disabled people exist. I say this as a white woman myself who benefits from many of the clauses and sections in these pieces of legislation. So it is simply not possible that these laws addressing historically disadvantaged people discriminate against white people. And that is not even to mention the fact that a number of the laws included on the list are pre-democratic race laws. So how exactly would any of those be discriminatory against white people? I mean, we discussed the Colored Persons Education Act that is included on this list. We discussed the Bethel-Thorpe Settlement Act. These are not acts that are in any way discriminatory towards white people, but are included on this list. So this list cannot be used to claim that all of these laws are discriminatory against white people. So anyone using this list to claim that there are 142 or 140 plus laws that discriminate against white people in South Africa is blatantly factually incorrect. And yet, this is the main way that this list is being used. And has the IRR done anything to combat this narrative? No, not really. In my opinion, they are happy to leave this list with all of its inaccuracies and flaws up online so that people can use it to claim white people are being discriminated against. This is the narrative that I believe they want to contribute to. I believe this is part of the reason that they do not list the sections or quote the laws that they have listed. Of course, they have said that they will do this in time, but this list has been up for years at this point, since 2022, and has been updated many times since then. If they were actually invested in providing this information, I believe it would have been done so by now. I mean, I've compiled this all in an Excel spreadsheet and here in this video, and cthulhucachoo has listed them out on Twitter and in their Substack post. It's a time-consuming and tedious task, yes, but it's not actually that difficult to do. It's a very simple case of if they really wanted to, they would. Between that, the inclusion of deracialized laws in the 142, and the seeming lack of effort or thoughtful reading of these laws, as can be seen by the inclusion of laws that mention white papers or biological diversity, I believe that there is a pretty deliberate intent to inflate the number that is included on this list as much as possible. And I specifically think it is to support and be able to make the claim that there are more race laws now than there were during apartheid. I do think that that is part of the reason. And based on what we know of the IRR as an organization, I just do not believe that the Race Law Index is an innocent academic endeavor to document and categorize laws in South Africa. It is rather, in my opinion, one part of a deliberate agenda to curate a narrative of white persecution in South Africa. This is a narrative that can only exist through a deliberate distortion and misrepresentation of reality. And that, in my opinion, is the truth about these 140 plus so-called race laws in South Africa.